There we go. We're back in action. So, we don't approve of the designation or the removal of the designation of a foreign adversary. The term joint resolution means a joint resolution of disapproval of the delegation. Disapproval of the designation, or a joint resolution of the disapproval of the removal of the designation. What? You can make sense of that. Don't have to say it again. The term joint resolution of a disapproval of designation means a joint resolution the matter after the resolving clause of which is as follows. Hello? What happened? Oh, wow. The tree fell?
A limb. I'm assuming it got struck by lightning or something.
Yeah, wow. Is that right outside? Yeah. Holy dick. Okay.
I just wanted to show you.
Hell yeah. Yeah. God damn.
Anyway, alright, I'm off.
I love you. Bye.
Love you. Bye.
Alrighty. Whoa, limb fell in the yard. Alright. The Congress disapproves the designation by the Secretary of Commerce of blank as a foreign adversary for purposes of securing the Information and Communications Technology and Services Supply Chain Act of 2023, and such designation shall have no force or effect until the Secretary of Commerce provides specific evidence to the relevant committees of Congress regarding the removal of the designation under the Section 6A of that act. The blank space being approximately filled with the name of the foreign person of which the foreign adversary of which the Secretary has designated as a foreign adversary for the purposes of this act, and the joint resolution of disapproval of the removal of designation means the joint resolution the matter after the resolving clause of which is as follows: that Congress disapproves the removal of the designation of the Secretary of Commerce of blank as a foreign adversary for purposes of securing the Securing the Information and Communications Technology and Services Supply Chain Act of 2023, and such removal shall have no force or effect until the Secretary of Commerce provides specific evidence to the relevant committees of Congress regarding the removal of designation under Section 6A of that designation as a foreign adversary for the purposes of this act. Expedited consideration of legislation. Initiation. In the event the Secretary designates a foreign government or regime as a foreign adversary or removes such designation as a foreign adversary, a joint resolution of disapproval of designation or a joint resolution of disapproval of the removal of designation as applicable, that is introduced during a 60 calendar day period thereafter, shall be entitled to expedited consideration pursuant to this subsection. Introduction. During the 60 calendar day period provided for in paragraph 1, a covered joint resolution may be introduced: A, in the Senate by the majority leader, or the designee of the majority leader, or the minority leader or the designee of the minority leader, and in the House of Representatives by the Speaker or the minority leader. Floor consideration in the House of Representatives. Reporting and discharge. If a relevant committee of the House to which a covered joint resolution has been referred has not reported such covered joint resolution within 10 legislative days after the date of referral, that committee shall be discharged from further consideration thereof. Proceeding to consideration. Beginning on the third legislative day after each committee to which covered joint resolution has been referred reports the covered joint resolution of the House has been discharged from further consideration thereof, it shall be in order to move to proceed to consider the covered joint resolution in the House. All points of the order against the motion are waived. Such a motion shall not be in order after the House has disposed of a motion to proceed on the covered joint resolution with regard to the same agreement. The previous question shall be considered as ordered on the motion to its adoption without intervening motion. The motion shall not be debatable. A motion to reconsider the vote by which the motion is deferred shall not be in order. It's a lot. We may have to revisit that. C. Consideration. The covered joint resolution shall be considered as read. All points of order against the covered joint resolution and against its consideration are waived. The previous question shall be considered as ordered on the covered joint resolution to final passage without intervening motion, except 2 hours of debate equally divided and controlled by the sponsor of the covered joint resolution or a designee and an opponent. A motion to reconsider the vote on a passage of the covered joint resolution shall not be in order. Consideration in the Senate. A committee referral. A covered joint resolution introduced in the Senate shall be referred to the relevant committee of the Senate. B. Reporting and discharge. If a relevant committee in the Senate has not reported such covered joint resolution within 10 session days after the date of referral of such legislation, that committee shall be discharged from further consideration of such legislation, and covered joint resolution shall be placed on the appropriate calendar. Proceeding to consideration, notwithstanding Rule XXII, so that means 22 of the standing rules of the Senate, it is in order at any time after each committee authorized to consider covered joint resolution reports it to the Senate or has been discharged from its consideration even though a previous motion to the same effect has been disagreed to move to proceed to the consideration of the covered joint resolution, and all points of order against covered joint resolution and against consideration of the covered joint resolution are waived. And the motion to proceed is not debatable. The motion is not subject to a motion to postpone. The motion to reconsider the vote by which the motion is agreed to or disagreed to shall not be in order. If a motion to proceed to the consideration of a covered joint resolution is agreed to, the covered joint resolution shall remain the unfinished business until disposed of. Debate on covered joint resolution, on all debatable motions, and appeals in connection therewith shall be limited to not more than 10 hours, which shall be divided equally between the majority and the minority leaders of the designees. A motion to further limit debate is in order and not debatable. An amendment to, or motion to postpone, or motion to proceed to the consideration of other business, or a motion to recommit in the covered joint resolution is not in order. Vote on passage. The vote on passage shall occur immediately following the conclusion of the debate on the covered joint resolution, and a single quorum call at the conclusion of debate if requested in accordance with the rules of the Senate. Rulings of the chair on procedure. Appeals from the decisions of the chair relating to the application of the rules of the Senate as the case may be to the procedure relating to the covered joint resolution shall be decided without debate. Consideration of veto messages. Debate in the Senate of any veto message with respect to a covered joint resolution including all debatable motions and appeals in connection with such covered joint resolutions, shall be limited to 10 hours. Let me see. I want to make sure that I'm still visible. Where am I at? Oh, wait a minute. I forgot this was even a thing I could do. Now, how does that do? That really makes everything a lot nicer, huh? You like this, huh? How about with you like that? I like it. I like it a lot. I like it long time. Yeah, sure. All right. Rules relating to the Senate and the House of Representatives. A. Coordination with action by other House. Coordination with action by other House. If before the passage of one House is a covered joint of a by one House of a covered joint resolution of that House receives a covered joint resolution from the other House, then the following procedures shall apply. The covered joint resolution of the other House shall not be referred to a committee. With respect to the covered joint resolution of the House receiving the legislation, the procedure in that House shall be the same. Let's see. Where am I at? Where am I at? Shit. Shall apply. The covered joint resolution of the other House shall not be referred to a committee. With respect to covered joint resolutions of the House receiving the legislation, the procedure in that House shall not be the same as if no covered resolution had been received from the other House, but the vote on passage shall be on the covered joint resolution of the other House. Treatment of a covered joint resolution of the other House. If one House fails to introduce a covered joint resolution under this section, the covered joint resolution of the other House shall be entitled to expedited floor procedures under this section. Treatment of companion measures. If, following passage of the covered joint resolution in the Senate then receives a companion measure from the House of Representatives, the companion measure shall not be debatable. Rules of the Senate and the House of Representatives, subsection B, is enacted by Congress. 1. As an exercise of the rule-making power of the Senate and the House of Representatives respectively, and as such are deemed a part of the rules of each House respectively, but applicable only with respect to the procedure to be followed in that House, in the case of legislation described in those sections, and supersede other rules only to the extent that they are inconsistent with such rules, and with full recognition of the constitutional right of either House to change the rules so far as relating to the procedure of that House at any time. In the same manner, and to the same extent as in the case of any other rule of that House. The effect of covered joint resolution. Joint resolutions of disapproval of designation. A joint resolution of disapproval of designation that is enacted in accordance with this section shall remove the designation as a foreign adversary of the foreign government or regime that is the subject of a joint resolution of disapproval of designation for the purposes of this act. Joint resolutions of disapproval of removal of designation. A joint resolution of disapproval of removal of designation that is enacted in accordance with this section shall prohibit the removal of designation as a foreign adversary of any foreign government, or regime that is subject to the joint resolution of disapproval of the removal of designation for the purposes of this act. Section 8. Implementing authorities. Regulations. I think I just prefer bending down a bit. Implementing authorities. Regulations in carrying out the responsibilities under this act. The Secretary may establish such rules, regulations, and procedures as the Secretary considers appropriate. The classes of transactions and conducting reviews, promulgating regulations. Give me this lovely little old word. This lovely little old word. Cannot find the requesting verb promulgating. That's not what I want. Make widely known. Okay. Promulgating regulations implementing prohibitions or other mitigation measures or otherwise carrying out the responsibilities under this act. The Secretary may take action with respect to both individual covered transactions and classes of covered transactions. Other authorities. In general, the Secretary may issue guidance, including adversary opinions, and establish procedures to carry out this act. List of foreign persons. The Secretary may create lists of foreign persons that may be subject to prohibitions or restrictions and related mechanisms to revise and update such lists periodically. Additional authority. The Secretary may undertake any other action as necessary to carry out the responsibilities under this act that is not otherwise prohibited by law. Advisory committees. The Secretary may appoint technical advisory committees to advise the Secretary in carrying out the responsibilities under this act. Chapter 10 as Part 1 of Title 5. United States Code shall not apply to any meeting of such advisory committee held pursuant to this subsection. Section 9. Information to be furnished. In general, the Secretary may require any party to a In general, the Secretary may require any party to a transaction or holding under review or investigation pursuant to this act to furnish under oath, in the form of reports or otherwise at any time may be required by the Secretary, complete information relative to any act, transaction, or holding subject to the provisions of this act. Authority. In carrying out this act, the Secretary may require that information or reports required to be submitted under subsection A include the production of any documents relating to any act, transaction, or property relating to the transaction or holding under review or investigation. Require information or reports required to be submitted under subsection A before, during, and after consummation of the transaction or holding under review or investigation, and conduct investigations, hold hearings, administer oaths, examine witnesses, receive evidence, take depositions, and require by subpoena the attendance and testimony of witnesses and the production of any documents and relating to any transaction or holding under review or investigation, regardless of whether any report has been required or filed in connection therewith, including through another person or agency. Now the format. Any person producing any document to the Secretary pursuant of this section shall produce the document in a format usable to the Department of Commerce, which may be detailed in the request for documents or otherwise agreed to by the parties. Confidentiality and disclosure of information in general, subject to paragraph 2. Any information or document not otherwise publicly or commercially available that has been submitted to the Secretary under this act shall not be released publicly except to the extent required by federal law. Disclosure. Notwithstanding paragraph 1, the Secretary may disclose information or documents that are not otherwise publicly or commercially available in the following circumstances: pursuant to the administrative or judicial proceedings, including judicial review under Section 12, pursuant to the Act of Congress, pursuant to a request from the relevant committee of Congress, pursuant to a request from a federal, state, or local governmental entity, or to any foreign government entity of the United States ally or partner, if such request is important to the national security, analysis, or actions of the Secretary, but only to the extent necessary for national security purposes and subject to the appropriate confidentiality and classification requirements. If any party to whom the information or documents pertain consents to such disclosure, if the Secretary determines in the sole and unreviewable discretion of the Secretary that the release of such information is in the national interest of the United States, any other purpose authorized by federal law. Section 10, Enforcement. A. Investigations. 1. In general, the President shall rely, including by delegation, the Secretary, and the heads of the other federal agency as appropriate to conduct investigations of violation of any authorization, order, mitigation measure, regulation, or prohibition issued under this Act. Actions by designees in conducting investigations described in paragraph 1, designated officers or employees of federal agencies described that paragraph may, to the extent necessary or appropriate to enforce this act, exercise such authority as is conferred upon them by any other federal law, subject to policies and procedures approved by the Attorney General. Permitted activities. Officers and employees of agencies authorized to conduct investigations under subsection A may: 1. Inspect, search, detain, seize, impose temporary denial orders with respect to items in any form or conveyances on which it is believed that these items that have been, are being, or are about to be imported into the United States in violation of this act or any other applicable federal law. 2. Authorized to conduct investigations may require, inspect, obtain books, records, or any other information from the person subject to the provisions of this act or other applicable federal law, administer oaths or affirmations, and by subpoena require any person to appear and testify or appear and produce books, records, and other writings, or both, and obtain court orders and legal processes to the extent authorized by chapters 119, 121, and 206 of Title 18 United States Code and any other applicable federal law. Enforcement of subpoenas. Subpoenas. In the case of contumacy by or refusal to obey a subpoena issued to any person under subsection B3, a district court of the United States, after notice to such person and a hearing, shall have jurisdiction to issue an order requiring such person to appear and give testimony or to appear and produce books, records, or other writings, regardless of format, that are subject to the subpoena, and any failure to obey such order of the court may be punished by the court as contempt thereof. Actions by the Attorney General. The Attorney General may bring an action in an appropriate district court of the United States for appropriate relief, including declaratory and injunctive, or divestment relief, against any person who violates this act, or any regulation, order, direction, mitigation measure, prohibition, or other authorization or directive issued under this act, and any such action and the limitations as described under Section 12B shall apply. Section 11. Penalties. Unlawful acts. In general, it shall be unlawful for a person to violate, attempt to violate, conspire to violate, or cause a violation of any regulation, order, direction, mitigation measure, prohibition, or other authorization or directive issued under this act, including any of the unlawful acts described in paragraph 2. Specific unlawful acts. The unlawful acts described in this paragraph are the following: no person may engage in any contact prohibited by or contrary to or refrain from engaging in any conduct required by the regulations, order, direction, mitigation, measure, prohibition, or other authorization or directive issued under this act. No person may cause or aid, abet, counsel, command, induce, procure, permit, or approve the doing of any act prohibited by or omission of any act required by the regulation, order, direction, mitigation, measure, prohibition, and other authorization or directive issued under this act. No person may solicit or attempt a violation or of any regulation, order, direction, mitigation, measure, prohibition, or authorization, directive issued under this act. No person may conspire or act in concert with one or more other persons in any manner or for any purpose to bring about or do any act that constitutes a violation of any regulation, order, direction, mitigation, measure, prohibition, or other authorization or directive issued under this act. No person may, whether directly or indirectly through any other person, make any false, misleading representation, statement, or certification, falsify or conceal any material fact to the Department of Commerce or any official of any other executive department or agency in the course of an investigation or other action subject to this act or any regulation, order, direction, mitigation, measure, prohibition, or any other authorization or directive issued thereunder. In connection with the preparation, submission, issuance, use, and maintenance of any other report, files required to be filed pursuant to this act, or any regulation, order, direction, mitigation, measure, prohibition, and other authorization or directive issued thereunder, no person may engage in any transaction or take any other action with intent to evade the provisions of this act or any regulation under direction, order, direction, mitigation, measure, prohibition, or other authorization or directive issued thereunder. No person may fail or refuse to comply with any of the reporting, record-keeping requirement of this act. Any regulation, order, direction, mitigation, prohibition, other authorization, directive issued thereunder, except as specifically authorized in this subchapter. Any regulation, order, direction, mitigation, measure, or other authorization or directive issued thereunder or in writing by the Department of Commerce, no person may alter any order, direction, mitigation, measure, or other authorization or directive issued under this act or any related regulation. Additional requirements. A continuation of effect. For the purposes of paragraph 2E, any representation, statement, or certification made by any person shall be deemed to be continuing in effect until the person notifies the Department of Commerce or relevant executive department or agency in accordance with subparagraph B. Notification. Any person who makes a representation, statement, or certification to the Department of Commerce or any official of any other executive department or agency related to any order, direction, mitigation, measure, prohibition, or other authorization or directive issued under this act shall notify the Department of Commerce or the relevant executive department or agency in writing of any change of any material fact or intention from that previously represented, stated, and certified immediately upon the receipt of any information that would lead a reasonably prudent person to know that a change of material fact or intention had occurred or may occur in the future. Civil penalties. The Secretary may impose the following civil penalties on a person for each violation by that person in this act, any regulation, order, direction, mitigation, measure, prohibition, or other authorization under this act, a fine of not more than $250,000, or an amount that is twice the value of the transaction that is the basis of the violation with respect to which the penalty is imposed, whichever is greater. The revocation of any mitigation measure or authorization issued under this act to a person. A person who willfully attempts to commit, or willfully conspires to commit, or aids in or abets in commission of an unlawful act described in subsection A shall, upon conviction, be fined not more than $1 million, or if a natural person may be in prison for not more than 20 years or both. Civil forfeiture. That was criminal penalties. Forfeiture. In general, any property, real or personal, tangible or intangible, used or intended to be used in any manner to commit or facilitate the violation or attempted violation described in paragraph 1 shall be subject to forfeiture to the United States. Proceeds, any property, real or personal, tangible or or intangible, constituting or traceable to the gross proceeds taken, obtained, or retained in connection with or as a result of the violation or attempted violation described in paragraph 1 shall be subject to forfeiture to the United States. Procedure. Seizures and forfeitures under this subsection shall be governed by the provisions of Chapter 46 of Title 18 United States Code relating to civil forfeitures, except that such duties are imposed on the Secretary of Treasury under the customs laws described in the section of 981D of Title 18 United States Code, shall be performed by such officers, agents, and other persons as may be designated for that purpose by the Secretary of Homeland Security or the Attorney General. Criminal forfeiture. Forfeiture. Any person who is convicted under paragraph 1 shall, in addition to any other penalty, forfeit to the United States any property, real or personal, tangible, used to be intended to use in any manner to commit or facilitate the violation or attempted violation of paragraph 1, and any property, real or personal, tangible, intangible, constituting or traceable to the gross proceeds taken, obtained, or retained in connection as a result of violation. Procedure. The criminal forfeiture of property under this paragraph, including seizure and disposition of property and any related judicial proceeding, shall be governed by the provisions of Section 413 of the Controlled Substances Act, except some sections A and D of that section. Judicial review. Definition. In this section, the term classified information has the meaning given the term in Section A, 1A of the Classified Information Procedures Act, 18 U.S.C. App, and includes any information or material that has been determined by the federal government pursuant to an executive order, statute, or regulation to require the protection against unauthorized disclosure for reasons of national security, and any restricted data as defined in Section 11 of the Atomic Energy Act of 1954. Goddamn. Administrative and judicial review. Notwithstanding any other provision of law, actions taken by the President and the Secretary and the findings of the President and the Secretary under the Act shall not be subject to administrative review or judicial review in any federal court except as otherwise provided in this section. Actions taken by the Secretary under this Act shall not be subject to Sections 551, 553, or 559, or 701 or 707 of Title 5 United States Code. Petitions. In general, not later than 60 days after the Secretary takes action under Section 3A or the President takes action under Section 4C, an aggrieved person may apply for review by filing petition with the United States Court of Appeals for the District of Columbia Circuit. Standard of review. The court shall not disturb any actions taken by the Secretary under Section 3A or by the President under Section 4C unless the petitioner demonstrates that the action is unconstitutional or in patent violation of clear and mandatory statutory command. Exclusive jurisdiction. The United States Courts of Appeals for the District of Columbia Circuit shall have exclusive jurisdiction over claims arising under this Act against the United States, any executive department or agency, or any component or official of an executive department or agency, subject to the review of the Supreme Court of the United States under Sections 21254 of Title 28 United States Code. Administrative record and procedure. In general, The procedures described in this subsection shall apply to the review of a petition for review under this section. Filing record. The United States shall file with the court an administrative record which shall consist of the information that is appropriate official relied upon in taking a final action under this act. Unclassified, non-privileged information. All unclassified information contained in the administrative record filed pursuant to the paragraph 2 that is not otherwise privileged or subject to statutory protection shall be provided to the petitioner with appropriate protections for any privileged or confidential trade secrets and commercial financial information. In camera and ex parte review. The following information may be included in the administrative record and shall be submitted only to the court ex parte and in camera. Sensitive security information as defined by 1520.5 and Title 49 Code of Federal Regulations. B. Privileged law enforcement information. C. Information obtained or derived from any activity authorized under the Foreign Intelligence Surveillance Act of 1978, except that with respect to such information in subsections C, E, F, G, and H in Section 106, subsections D, F, G, H, and I of Section 305, subsections C, E, F, G, and H in Sections 405 and Section 706 of the Act shall not apply. There's a lot of pretension going on here. Like, they don't want you to be able to know what it's saying unless you have done the prior reading. So it looks like we got to start at the beginning after this. This is my introduction. Is this the full law? Nuh-uh. I got nuh-uh for $20. Alrighty. Information subject to privilege or protection under any other provision of law, including the Currency and Foreign Transactions Reporting Act of 1970. Information under seal. Any information that is part of the administrative record filed ex parte and in camera under paragraph 4 or cited by the court of law in any decision shall be treated by the court consistent with the provisions of this section. In no event shall such information be released to the practitioner as part of the public record. Return. After the expiration of time to seek further review and the conclusion of further proceedings, the court shall return administrative record, including any and all copies, to the United States. Exclusive remedy. A determination by the court under this section shall be exclusive judicial remedy for any claim described in this section against the United States, any executive department or agency, or in any component or official of any such executive department or agency. Mother God. Rule of construction. Nothing in this section shall be construed as limiting, superseding, or preventing the invocation of any privileges or defenses that are otherwise available at law or in equity to protect against disclosure of information. Section 13. Relationship to other laws. In general, except as expressly provided herein, nothing in this act shall be construed to alter or affect any other authority, process, regulation, investigation, enforcement measure, or review provided by or established under any other provision of federal law, including the Federal Acquisition Regulation or the Internal Emergency Economic Powers Act, or any other authority of the President of Congress under the Constitution of the United States, relationship to Section 721 of the Defense Production Act of 1950, in general notwithstanding Section 721D4B of the Defense Production Act of 1950, nothing in this act shall prevent or preclude the President or the Committee of Foreign Investment and the United States from exercising any authority under the Section 721 of the Defense Production Act of 1950 as would be available in the absence of this act. Authority to the President. The President may not exercise any authority under Section 4 with respect to the covering holding that directly resulted from the transaction if The Committee of Foreign Investment of the United States reviewed the transactions or a broader transaction that included the transaction as a covered transaction as defined in Section 721A4 in the Defense Production Act of 1950 and its implementing regulations, and under Section 721 of the Defense Production Act of 1950, the Committee for Foreign Investment of the United States cleared the transaction and notified the parties of the transaction or broader transactions that included the transaction that the Committee of Foreign Investment in the United States completed all action with respect to the transaction or a broader transaction that included the transaction, or the President announced a decision declining to take action with respect to the transaction or a broader transaction that included the transaction. Coordination. The Secretary shall address coordination with respect to review by the Committee of Foreign Investment and the United States and in implementing the procedures under this Act. Limitation of authority of the Secretary. The Secretary may not initiate a review of any transaction that involves the acquisition of an information and communication technology product or service by a United States person as a party to the transaction, authorized under the United States Government Industrial Security Program, or to meet an articulable national security law enforcement requirement. Transition. All delegations, rules, regulations, orders, determinations, licenses, and other forms of administrative action taken by the Secretary made, issued, conducted, or allowed to become effective under Executive Order 1387-3 of May 19 of 2019 and the International Emergency Economic Powers Act, including regulations issued under Part 7 of Subtitle A, Title 15, Code of Federal Regulations, are in effect as of the date of enactment of this Act, shall continue in effect according to their terms as if made, issued, conducted, or allowed to become effective pursuant to the authority of this Act until modified, superseded, set aside, or revoked under the authority of this Act without regard to any restriction or limitation under the International Emergency Economic Powers Act. Miscellaneous. Paperwork Reduction Act. This requires the requirements of Chapter 35 of Title 44 of the United States Code, commonly referred to as the Paperwork Reduction Act, shall not apply to any action by the Secretary to implement this Act. Appointments of candidates. To expedite the ability of the Secretary to implement this Act, the Secretary may appoint, without regard to the provisions of Sections 3309 through 3318 of Title 5 United States Code, candidates directly to positions in the comparative service as defined in Section 212 of that title. The administrative procedures, except with respect to a civil penalty imposed pursuant to Section 9B of this Act, the functions exercised under this Act shall not be subject to Sections 551, 553 through 559, and 701 through 706 of Title 5 United States Code. Protected information in civil actions. If a civil action challenging an action or finding under this Act is brought and the court determines that the protected information of the administrative record, including classified and other information subject to privilege or protections under any provision of law, is necessary to resolve the action, that information shall be submitted ex parte and in camera to the court, and the court shall maintain that information shall under seal. This subsection does not confer or imply any right to judicial review. fact the hearing was held, but not the context of the hearing, become a matter of public record. Motherfucker. And the court shall maintain that information under seal. This subsection does not confer or imply any right to judicial review. Applicability of use of information provisions. The use of information provisions of sections 106, 305, and 405 and 706 of the Foreign Intelligence Surveillance Act of 1978, 1825, and 1845, and 1881 shall not apply in a civil action brought under this act. No right of access. In general, no provision of this act shall be construed to create a right to obtain access to information in the possession of the federal government that was considered in making a determination under this act that a transaction is covered action or interest, or to prohibit, mitigate, or take action against a covered transaction or interest, including any classified national security information or sensitive but unclassified information. And applicably of FOIA, any information submitted by the federal government by a party to a covered transaction in accordance with this act shall, as well as any information the federal government may create relating to the review of the covered transaction, is exempt from disclosure under Section 552 of Title V United States Code, commonly referred to as the Freedom of Information Act. Section 16. Severability. If any provisions of this act, the application of such a provision to any person or circumstances held to be invalid, and the remainder of this act, and the application of the remaining provisions of the act to any person or circumstance shall not be affected. Alright. Authorization of appropriations. There are authorized to be appropriated such sums as may be necessary to carry out this act. That's a lot to stew on. That's a lot to stew on. I'm gonna have to break it down eventually. Motherfucker. Motherfucker. I don't know, motherfucker. 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 I don't know you. You don't know me. I don't know you. You don't know me. I don't know you, motherfucker. I don't know you. You don't know me. I don't know you. You don't know me. Motherfucker. 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 And that is it, man. Now, I reckon